Welcome dear students again for my next lesson regarding the Contract Act. We have already discussed in the Contract Act the part of the consideration and importance of section 25 in 11th lesson. Important of section 25 in the 11th lesson we have already discussed. Now, today what we are going to discuss? Today we are going to discuss exceptions to section 25. What section 25 says altogether? Section 25 says that where there is no consideration, no contract. But in a few of exceptional cases, even though the agreement is not supported by consideration, the agreement will be treated as a valid contract. What are those circumstances? Under which circumstances section 25 is not applicable? The first and foremost important case is a promise made with natural love and affection. A promise made with natural love and affection, and provided this promise made with natural love and affection must have to be supported by a few of other conditions also. Until and unless satisfaction of other conditions, it will not be create any legal bind over on the parties. What are those legal formalities? Number one, promise must be in writing. Promise must be in writing. B, promisor must have to sign. Sign means signature. C, it must be registered. It must be registered. Now, see the other conditions that must have to be fulfilled. What are the other conditions? Even though a promise made with natural love and affection, even though it was documented, that means even though it is in writing, if it is not signed by the promisor and if it is not registered as per the Registration Act, it will not create any legal bind over on the parties. Let me take a simple example. As long as the CPT exams are concerned, IPCC exams are concerned, or other exams are concerned, the one and only important case study that they will give you is a wife and husband always quarrels together because of unavoidable circumstances. A wife placed her husband in unavoidable circumstances and thereby husband executed a document in favor of wife to transfer some worth of property. But later on, he is not giving whole possession. He is not transferring the ownership. Quiet possession is not handed over by the husband to his wife. The same had been challenged by wife in the court of law. Here, the wife is arguing with the court that even though section 25 says that where there is no contract, where there is no consideration, there is no contract, here there are in the same act a few of exceptions also specified. As per those exceptions, even though there is no consideration, if a promise made by someone in the sense he is not that much of a far away person, they might be a nearest relationship, wife and husband, maybe father with son, father with daughter, daughter with father. Likewise, a relationship must be existed in between the persons who are transferring and who are promising to transfer something. And it also takes It will also be considered as one of the issues while examining the case in a court of law. But here the relationship in between the donor and donee, promisor and promisee here is wife and husband. Now, this lady is arguing that as far as the exceptions to the contract is concerned, as far as the exceptions to the contract is concerned, we both stands in near relationship. Number one, and the contract had been in writing, in writing, and it had been registered also. But right now, my husband is not allowing me to have the quiet possession. Hence, order him to allow me uh, to get the quiet possession of the property. Thereby, on the inquiry made by the courts, they came to know that these persons never live togetherly with some peace and with natural love and affection. They used to quarrel each other all the way, all the time. In such a case, the court will find that even though it had satisfied the three conditions, one of the important condition is there, which is missing here in this promise. What is the important condition missing here in this promise? Yes, very important condition. That promise must have to made with love and affection, love and affection. But here, what happened in this case? Here, they quarrel each other because of one way or other way. That lady, wife, placed her husband in a position to transfer the property, but not with a natural love and affection. Hence, the promise is not at all valid. Hence, Hence, without consideration, if your promise needs to be valid, it must have to fulfill the following conditions also. What are those following conditions, Andy? With the natural love and affection, promise must have to be made with the natural love and affection, and promise must be in writing, and promisor must have to sign. It must be registered. Otherwise, it will not create any legal obligations in between the parties. That is the first thing. The next thing that we have to discuss here is number two. Promise made to compensate past voluntary services. Promise made to compensate past voluntary services. Good. Let me put together the concept by taking a simple example. What it is? A promise made to compensate past voluntary services. Past voluntary services. Let me take a simple example regarding this. Say for example, a person by passing on road, he saw a person who is in a position, who fell down on the road, and he is needed a medical assistance, but no one is helping him. But at that point of time, this person is passing by the road, and he watched him, he witnessed him, and this person offered his help. This person hospitalized that person. Okay, the person who is uh, suffering some illness. Say for example, this is the other person, Y. This is X. X hospitalized this person as and when he observed that he is in a helpless position, and thereafter he moved on his own work. He never expected anything from this guy. But after curing completely, the doctors said to him, if you late by 5 minutes or 10 minutes, even in case if the person who is Mr. X didn't bring you to the hospital, I think your life may be lost. With that graciousness, with that kindness that he is having in his mind, he moved to the house of Mr. X and thanked Mr. X and promised to pay 20,000 rupees, to pay 20,000 rupees, which may be helpful to the studies of this person's daughter, which may be helpful to the studies of this person's daughter. No. Let me examine whether the promise made by Y to pay 10,000 rupees, whether it is valid or not. First of all, what is the promise made by X to Y? Y to X, I'm sorry, Y to X. Y promised to give 10,000 rupees to Mr. X. What is the consideration from Y to X? 10,000 rupees money. What is the consideration in turn to Mr. Y? There is no consideration. In case if you opine that already X assisted Mr. Y in the past, what I am asking you is, at that point of time when Mr. X is assisting Y, X expected, shall X expected anything from Mr. Y? Is there any fixed agreement in between Mr. X and Y to compensate X assistancy or X services? No. At that point of time, X don't know at least who is Mr. Y. X rendered the services voluntarily, without expecting anything. But here, after curing, why promising to compensate? I will compensate your services because of you hospitalized me. I am right now alive. Otherwise, I may be died off. Because of you only, I am here. Hence, only to help your daughter's study, marriage, or whatever it may be, I am going to give you 10,000 rupees. Now, Mr. Y promised to compensate X past voluntary services. Hence, even though there is no consideration from the X to Mr. Y, the promise made by Y without consideration is also falls under the exceptional case of section 25. Is also falls under the exceptional cases of section 25. The third exception to section 25. The third exception to section 25. Section 25, third exception. Promise made to pay. Promise made to pay a time barred debt. A promise made to repay a time barred debt. Before discussing this, one must have to know, what do you mean by time barred debt? The definition of the time barred debt not given in the Indian Contract Act. It comes under the Limitation Act. As far as Limitation Act is concerned, in case two persons are there, say for example, he is the borrower and he is the lender. In our commerce language, the borrower will be treated as the debtor and the lender will be treated as the creditor. Good. When lender lends money to Mr. X with the documentation or without documentation, with a oral promise or whatever it may be the promise, I am not going to discuss all the stuff. Limitation Act says that when lender lends money to the borrower, lender is allowed legally 3 years. Lender is allowed legally 3 years a legal right of recovery over the debtor. Lender is having 3 years of time over the debtor legally to bind him for the recovery of the money. In case if the lender within this said 3 years he must have to do one thing. First of all, the first thing and important thing is he must have to collect the money. Yes, in case if he collects the money, the movie is end over there itself. The episode ends in a peaceful way, no problem. In case if he is not able to collect the amount, at least within the expiry of these 3 years, he must have to at least renew the debt. Renew the debt. The second thing, or at least he needs to bring a case against, bring a suit against borrower for the recovery. For the recovery, what Mr. Lender needs to do here? Mr. Lender needs to do within these 3 years, as per the Limitation Act, either collect the money, get back the money, or at least renew the debt, or brought a case against the debtor or the borrower. Without doing any of the acts within this 3 year, once the 3 years period is lapsed from the date of the borrowing, the lender loses legal right. Legal right. Why? When the 3 years lapses without doing anything, without any action taken by the lender loses the legal right of recovery. Hence, it will become as a time barred debt. Hence, it will become as a time barred debt. Now, let me come to the present discussion, because it is very important. A few of students may be confused what might be a time barred debt. Because of that reason only, I explained what do you mean by a time barred debt. Good. Now, what do you mean by the time barred debt? We have already discussed. Let me comes to the main point. Now, see here. Mr. X borrowed rupees 1 lakh on 1/1/2015 from Mr. Y. Thereby, he is the borrower and Mr. Y is the lender. But here in this case, this is 2016 is the first year, 2017 is the second year, 2018 is the third year. For example, why left Mr. Borrower, because of whatever it may be the reason, why didn't take any action or he didn't recover the money up to the 3 years. Now it became as a time borrowed debt. But because of the borrowed money helped Mr. X a lot. Because of the honesty remained in Mr. X. Because of all these reasons, X decided to repay even though after 3 years and more to Y and promised to pay the amount. Promised to pay the amount. Now, let me examine this issue. This is the situation of after 3 years. After 3 years, law deems that there is no contractual relationship or contractual obligation or bind over on Mr. X to repay the money. Hence, there is no contract in between X and Y. There is no contract at all in between Mr. X and Y. Good. Hence, X is a stranger to Y, Y is also stranger to X. But now X promises to pay the borrowed money of 1 lakh. But X promised to pay the borrowed money of 1 lakh. This is the consideration from Mr. X to Y. Is there any consideration from Mr. Y to X? No. As far as you may treat it, sir, already X had taken 1 lakh money before 3 years or 4 years. That only I am saying. In case of 3 years, there is no legal relationship in between both the parties. Hence, X need not to pay anything. But here X again promised. The actual situation is this. As far as if we apply section 25 is as it is re-applicable. Why? Why? Because from X, Y is having 1 lakh, but X is not having any promise. But it falls under the exceptions. It falls under the exceptions because even though X now promising to pay Y, it is a time barred debt. But promise made to pay time-barred debt must also have to be satisfied. Three more conditions. Three more conditions. What are those three more conditions? One is promise must be in writing. The second one is signed by the promisor. Signed by the promisor, and it must be legally dischargeable amount. Legally dischargeable amount. Okay, in writing, you may understand very easily. Signed by the promisor. Of course, now when Mr. X is promising to repay the time bar debt, he must have to sign the document. And what do you mean by legally dischargeable? For example, assume before 3 years, X and Y sit in a, gambling, and because of that gambling, because of the loss of gains in the gambling, X is indebted to Mr. Y. After 3 years or 4 years, now X is going to promise to pay that lost amount in the gambling. As far as the law is concerned, gambling is a unlawful activity. Hence, it is not a legally dischargeable debt. In such a case, even though X now promised, even though it is in writing, even though signed by the promisor, it will not create any legal bind over upon Mr. X because it is not legally dischargeable debt. Hence, in case if satisfied all these three conditions, then even though right now there is no consideration to the promisor, the promise is still valid promise. Okay, good. The remaining topic that we will discuss in the next class. Thank you.